Good morning, good morning, good morning. Wake up, wake up, wake up. It's that time again. I gotta get into this. My buddy told me I have to do this, so it's mandatory. What we're gonna talk about is how would you say? We won't say the corrective action. We'll just say, basically, we're gonna say the cause of action. The cause of action would be from the beginning where, oh boy, the dirty director did what he did with his motor vehicle in the whole 9 yards, and he violated the corporate compliance policy as well as state and federal laws, as long and local laws as well. Okay, the key thing is after he did the car incident or when he did the car accident, you got to understand you're in your place of employment. You're at work. So your actions are subject to accountability. So let's go with the fact of, based on the facts, we're going to deal just with the facts of him using his car in a threatening manner. The use of the car in a threatening manner would constitute violation of the corporate compliance policy under intimidation. When you go into intimidation, you bring in New York State Penal Law Code 13560 under threat and coercion. When you say under threat and coercion, you're going to go all the way down to number 8. In his position, he used his job position to be able to do what he wanted to do, which is to, cause this fear. Now, we also going to go to, because you're using a motor vehicle in that manner, we're going to go to New York State Traffic Law 1212. 1212 goes under reckless driving using a motor vehicle. In that same act, we would go to New York State Penal Law Code 12020 under recklessness. Okay. The mere fact that he came into the lot, pulled to the side, and waited for me to come out in the way where he could use the vehicle in a threatening manner, that would constitute stalking. They're still in that 120. I don't know, I think it's 120, 25, something like that. I'm not sure. You know. We're going to also go into the fact that you're a public employee, you have a shield. You're a public employee, so you're a public servant. Yeah. So you're acting doing that on public property at your workplace, that would constitute 19500 official misconduct. Then you're doing it on the property with your place of work. You're doing it like I'm working doing this. You're working doing this? Okay. That would be 2020. Liability on the 2020 and liability on 2025 because you are an officer or employee or supervisor, director, and using your job as it to do what you wanted to do. So right there's several laws already violated. So we're going to stick with that fact right there and how under the corporate compliance policy, the officer was required to file a complaint. So the officer did. He filed a complaint. Now, the key fact that you did these things, when the officer returned for duty, you had the parking attendant tell the officer, "Yo, your boss said for you to go park your car in the visitor's parking lot or park it on the street." Key thing is the officer pays for parking. He was assigned to that parking area before the director even got there. Yes, the director started work in April 2008. The officer was parking since March 2006. The incident occurred in July 2008. Be advised, all employees once hired are on a 1-year probationary period. So when the director did this to the officer, threatening actions in all 9 yards, while on probation, such actions constitutes gross misconduct. And under gross misconduct, the director is subject to immediate dismissal. This is in the employee's personnel rules and regulations policy. Said action not to follow your government policies brings about an act of what we call improper governmental action. Yeah, that would be that. And if it's not going to be that, then it's going to be an act of deceptive practice. That would be under 346 of New York State business law. Okay? Now, the mere fact that when the officer returned and he told them not to let him in, that would go under that Jackie Robinson. I like to call it the Jackie Robinson. Why? What was Jackie Robinson's number? Number 42, right? Yeah, U.S. Code 42, deprivation of a right or privilege. How can you deprive somebody of a right or privilege? You just got here. The actions in doing that's a no-no. That's under the U.S. Constitution. That's a constitutional law. That's a federal law. So my question is, how, once this incident was reported to the captains, and the captains, that would be Captain Bottoms and Captain Filianso, said, go to the EEO, which was Barbara Morano. Report it to Barbara Morano. And you go to Barbara Morano's office and you report it. She's supposed to document it. She's a public servant. She's supposed to document it. It's in her job. After she takes the document or takes the complaint, she's supposed to further it. Because this is under the corporate compliance policy. It says how to report a compliance issue. It says you talk to your supervisor or a member of management. Or a member of management. So, being that the supervisor was talked to or addressed about the matter, the supervisor said, go to management, which was the EEO for human resources. So, the human resources director or EEO official was supposed to take and document the information and then further the information on down to the corporate compliance officer, which the corporate compliance officer was supposed to take the information and forward it to the DOI investigator. And the DOI investigation was supposed to conduct the investigations. This part was basically flushed down the toilet. So the director was allowed an opportunity to take those hours or those times for when the officer had to suffer for being abused by not parking into his parking lot or getting in late to park in his assigned parking area, arriving early but not being able to get in because of the deceptive practices. The director used that time to bring up charges of time and attendance as far as lateness, excessive lateness caused by him under his directive. And then here it is, labor relations takes and uses this fraudulent action. You want to take this? These are fraudulent actions, fraudulent charges. These foul charges are a violation of Penal Law 175-35, or for instrument for filing with false written statement. Even if you don't want to say which is a Class E felony, even if you don't want to say if it's 35, it's 30. 175-30, or for an instrument for filing with false written statement. It's Class A misdemeanor. Now, let's move forward. You done did this, right? Yeah. So you filing these documents, right? Would that fall under obstruction of governmental administration, which is 195.05? Yes, it would. You're doing something that's fraudulent, right? Yeah, you're doing it with intentions, right? You're also taking this information, you're filing it with the union, with other entities for the rector as well. So if you're filing it with 40 rector in the whole 9 yards with all of this fraudulent information, and you have what you call some type of scheme going on where you have an intent to cause somebody injury through your actions or omissions, which is a injury through breach of contract. See, when you breached your contract, you brought about a crime of omission through an act or omission. Something that you are required to do by law. So, since you took and you filed this with these other entities and you pushed this document along, that would go and fall under corrupting the government, right? Wouldn't that be subsection 496.02? Which would be a Class E felony as well? Come on, let's tell the truth now. Now, you taking this false information, you got the union to work with you, the grievance coordinator, who's a litigation attorney, who's not doing his proper thing, and then you got your representing attorney who's not doing the right thing. Both of them by what? Violations of Canons 9, the appearance of an impropriety. Then they're going to bring it to a judge. Violations of Canons 2, the appearance of an impropriety. The judge and the lawyer is supposed to avoid it. As far as the lawyers, it falls under New York State Judicial Code of Conduct, Part 1200. As far as the litigations or lawyer, the grievance coordinator, he was supposed to report the employer's lawyer for the fraudulent information that she had filed on the record, the improprieties. That would be under reporting misconduct. That would be 8.3. His failure to do so will be 8.4. That would be misconduct. This falls on their character, under their truthfulness, their honesty. This also falls on their position as an attorney. This is something that will go to the Judicial Committee and should be addressed with the Judicial Committee. The mere fact that the judge says, you know what, I'm going to continue on with that, would bring about what we call an ultra-virus. See, because you have the Canons law and you're trying to proceed with it, Canons law, you can't go beyond your Canons law. The ultra-virus explains why it's beyond your powers, because under your Canons law, the mere appearance of improprieties is supposed to stop. You do know a courthouse is a ship. And if the ship has a number of holes in it, it's going to sink. So the ship sunk. There was no way it could set sail. Based on the fact of, from the beginning, the violation of the corporate compliance policy, the violation of all the state laws and the state laws, and then even the federal law. That boosted up to Civil Service Law Section 75B under whistleblowers protection, where you're not supposed to do anything, but you continued on. Then let's not just forget 75B. Let's go into New York's labor law, 740. Also falls under improper governmental actions. Then we're going to go to New York's local law, number 33. All under whistleblowers protection. Explain why you did that. I'm not going to go far with this. I just want you to be able to explain that. Better yet, how was the director able to remain on staff for 8 years with all his corruption that he was doing? Illegal termination and suspension of people? If not, why did they change the hospital police director's position to chief? I'm waiting for an answer. You do your research, all right? Do your research and get back at me, all right? And I'm out. Have a wonderful day. Later.